Most people think estate planning is deciding about who gets their assets when they die. But reality is a complete estate plan answers two separate questions. Who can step in and help if you're still alive, but unable to handle your affairs? And then who takes over after you're gone and who manages that estate, cares for your children, and so forth. So understanding which documents apply during life versus after death will help you better eliminate those common confusions that take place. Welcome in. This is Complete Estate Planning. I am Ben George with Nick Rosenbauer, the Rosenbauer Law Office. And Nick, today we're talking about these kind of two separate discussions, right? I think a lot of people just assume estate planning is all about kind of taking care of, what happens when I'm gone, right? But there's a lot more to it.
Well, right. And so you're exactly right. When people, not always, but most people who reach out to us, I think what is top of mind on their concern list is when I am gone, what happens with my assets? And then, if you have minor children, where do they go? So I think that's the main, alarm bell, if you will, that's going off in someone's head. But one thing we also need to be aware of, and I tell people, obviously the first part's the selfless side of estate planning. When I'm gone, how do I take care of everyone else? But there's also the piece of the selfish side, which is while I am still alive, before we're doling out an inheritance plan, but if I get sick, if I'm unavailable, if I need someone to manage things, step in on my behalf, who do I want to do that and give someone the authority to do that? So a lot of people, and again, it's good, Ben, because they're looking at this from a selfless lens of I'm leaving the world in a better place than I found it for others. But I tell them that's important, but we also need to look in the mirror and make sure if something happens to you, then someone is able to take care of things, when you need to be taken care of, but you can't do it yourself.
Very good. So, yeah, this video is going to kind of walk you through that, right? The planning for life, what items are on that list, that checklist, things you need to take care of, and then also the planning for death, right? What's on that list and what documents apply in that situation as well. Remember, again, everything can be found online. CincinnatiEstatePlan.com is the website. Also the phone number 513-463-6789. So we'll start with life, Nick, in this kind of side of the planning. So what else kind of are we fitting under this umbrella, so to speak?
Yeah, so we'll look at the selfish side of it first. But I guess the one sentence answer would be, if you're still alive and you need things to be handled for you, whether it's, decisions, signing something, just taking care of you personally, and you can't speak, make decisions, or act for yourself, someone needs to be able to step in for you and take care of that. And I will say one thing, Ben, that I think a lot of our listeners will be, familiar with a lot of these documents, or at least the concept. And actually, I've heard a lot of people who were surprised to find out that this is part of estate planning. But like as an example, the first thing would be, most people probably heard of power of attorney. There's two different powers of attorney, which obviously our listeners would know. We've spoken about on this show before. The first one is for financial or legal decisions. So if you're still alive, even though you haven't passed away yet, and we're not worried about an inheritance at this point, if you can't pay your bills, someone has to do that. If you can't go to the bank, someone has to do that. If we need to withdraw money, invest money, sign a contract, heck, Ben, if we need to renew the registration on your car, that needs to be done. File your taxes. Okay. The IRS doesn't care if you just had a stroke. They want the taxes filed and they want you to write the check, right? For whatever you're owed. So, the financial power of attorney allows someone to make those decisions, act and sign on your behalf. And so they basically step in your shoes. Now, one thing to be aware of here is this is only while you're alive. This is not something where it will continue, from life into death. And I think a lot of people get confused by that. They'll come to me saying, parents passed away, now bills need to be paid. And they say, well, I was mom's power of attorney, I was dad's power of attorney. Well, that authority ends when someone passes away. So these these incapacity documents are only during the client's lifetime. And then it'll switch, which we'll talk about in a minute. So that's the financial or legal decisions, the one power of attorney. And the other one, of course, is medical, obviously. So instead of signing checks, paying bills, et cetera, we're talking about, if you're sick, going to the hospital, making medical decisions on your behalf. If you're not able to make them for yourself, accessing medical information, deciding what treatment option to do or not do. And, that one also ends at death. So we're kind of in the same boat here. I think there's less confusion with that as opposed to the financial power of attorney, because obviously when someone passes away, there's not a whole lot more medical decisions about them to make, but it functions the same way the financial power of attorney does. So you've passed away, and so any power of attorney that you've granted will end at that point. So again, just another piece to be aware of. And then the last one, which I know we've talked about this as well, and this is very state specific. Put the legal disclaimer, at the bottom for this one. But states have different living will, advanced medical directive documents as well. Ohio calls it a living will. Most states call it advanced medical directive. Frankly, some states have it all built into one medical document, which I like better, but here in Ohio, we like to be special. And it's really, I guess it's the supplement or the dance partner, as I say it, to the medical power of attorney. You need it. It goes with the medical power of attorney, but instead of appointing someone to make decisions for you, they are going over specific end-of-life kind of affirmative decisions you get to make for yourself, such as artificial life support, comfort care, depending on the state, organ donation, all of those decisions on, basically how you want your body to be treated, when you're a permanent brain dead vegetable, for lack of a better term. So again, that's another one to be aware of. It's not a decision-making document, so I don't think we get a lot of confusion about when it applies. But I do want our listeners to be aware that, with your powers of attorney, both financial and medical, your attorney should be doing this advanced directive. If you are in a state, of course, where it's a different document. Obviously, if it's a state where it's all roped into one document, even easier, but that needs to be on your radar as well. Mm-hmm. And obviously, these are not inheritance decisions. These are not taking your money and passing it on to someone else. This is, while we're still alive. I'm trying not to make the Monty Python "I'm not dead yet" reference here, but just I think the joke writes itself. Hopefully, our listeners are, I don't know if we'll call them cultured enough to have seen to see Holy Grail. Our listeners seem pretty sophisticated, right?
Yeah, exactly. I would say that.
So yeah, those are the big ones that are incapacity or during life only that you need to be aware of, and they're a big part of your estate plan. So this is something, like I said, that most people forget about, or is at least not on the top of their to-do list when they're calling me or when they're calling an attorney.
Yeah. So a few things there to kind of keep in mind. Is there anything else there on the living side that you need to kind of pay attention to before we shift over to planning for death?
Yeah. So a little kind of specific detail here to be aware of. If you are setting up a trust as opposed to a will, even though it works as a will substitute, the trust can also be in play and assist you while you're alive. Okay, it does. Again, it goes beyond the will, which we'll talk about in a minute. And not only does it deal with the inheritance, but also whoever you pick to be in charge as a backup trustee, what is also or should be baked into that trust is, if you are still alive and you need someone to manage the trust, manage the assets, carry out your wishes while you're still alive, the backup trustee will have the ability to do that for you. Now, again, that's almost that's almost like an extension of the power of attorney job. I think is probably a good way to describe that. But if you create a trust and you're in charge of the trust, you'll have backup trustees that will take over after you pass away. But if you're incapacitated, even if we're not ready for the inheritance, there should be someone written into the trust as a backup to step in and do your job as trustee while you're still alive if you're not able to do it yourself, which for a will we'll talk about in a minute. That's not applicable at all within a will. So that's going to be a different experience or checklist for people, whether they're doing a will or a trust.
All right, again, reach out if you haven't had these planning conversations, right, and maybe you haven't gotten some of these documents in order. Now's the time. You can always reach out and discuss with Nick. What's priority, what needs to take place now, how do I get these things in place? Again, CincinnatiEstatePlan.com. So, planning for life, right? So, talking about who can step into your shoes. Now we shift over to, hey, who takes care of you after you're gone, right? So, probably the area that more people are familiar with here, Nick. But what are some of the key points here we're paying attention to?
Well, at this point, we're looking at when I am gone. For everyone, what happens with my assets, with my inheritance. And then if you have underage children, this is where the guardianship also comes into play. So obviously the big piece here that should apply to everyone will be the inheritance. And that will be, I'd say the most common way to deal with that would be a last will and testament that says, when I am gone, here's what I want to have happen with my assets, my nest egg, and naming someone to be in charge of it. So the term in most states is called the executor. Personal representative is another term that is used. And then also if you have minor children, so people who are underage of adulthood, when you pass away, the parent has the legal authority, and I would argue responsibility, to nominate the guardians, which would be who would be the substitute parents. So if my kids, if my wife and I pass away tomorrow, my kids are underage. They can't live in the house alone, obviously. So we have guardians nominated to who will basically, take over and be the substitute parent, where they will go to live. So you need to be careful. Obviously, I'd say that's probably your most important job if we're picking jobs. But those are obviously only decisions that need to be triggered after someone passes away, which is typically, like I said, Ben, this is typically what is more top of mind or on people's radar or to-do list when they reach out to us. Now, one other item I want to go over, I know I mentioned before that a trust can be in play while you're alive and after you pass away. With a will, that is not the case. A will is useless, a will is worthless, and it has no effect while you are alive. It does not do anything until someone passes away. So even if I write a will tomorrow and I name you as my executor, you can't do anything while I'm alive. If I'm sick, you can't take my money, you can't take my kids, you can't manage my bills, you can't do any of those things. The executor's job only begins when I pass away, and it starts with after I have passed away, carrying out my inheritance wishes. Okay, so the will is worthless until someone passes away, where a trust has that incapacity, ability for someone to step in before you pass away, kind of that additional protection built into it, where with a trust, not only do you have that, and we'll call it phase 1 and phase 2, maybe that's a good way to describe it. And obviously after you pass away, it'll carry out the inheritance in the way that you want, picking the trustee that you want, and typically it's outside the purview of probate court. But yeah, I'd say the trust is really the only document that is applicable while you're alive and when you pass away, where powers of attorney, financial, medical, and other medical directives are only applicable while you're alive. And then once you pass away, they're irrelevant at that point. And obviously the will is the opposite of that. So while you're alive, the will means nothing. Once you pass away, then that is when the will comes into place.
Yeah, again, that makes a lot of sense. And I know you said that's kind of what everybody's paying attention to when they come and talk with you and start laying out a plan. So what else are some other areas that you have to make sure are taken care of, or what else do you want people to know about this process?
Well, it's really I'd say estate planning as a whole, like the big umbrella of what estate planning is, what we do is really two jobs in one. Okay, the first is if something happens and I'm still alive, who takes care of me, and my affairs? And then after I am gone, if I have children, who takes care of them, and then who takes care of my inheritance. So there's phase one and phase two. And regardless of the type of plan you use, will, trust, doesn't really matter. I want both of those to be on your radar because one without the other is not good. I have had people, typically they come from another attorney and they say, well, my attorney did a will. Okay, what about the rest of the documents? And they look at you and say, what other documents? They just did the will. So I think, unfortunately, Ben, there are attorneys out there who will just, basically take your order like we're at Burger King or Wendy's, in a drive-through, and provide no assistance, provide no guidance, or not even make people aware that we're only doing half of this or we're only doing a part of this. And the problem is I talk to people and they're surprised, and they say, and they should be, because look, it's not I don't think it's the client's responsibility to understand the legalese. That's why they call me, or that's why they call the attorneys, right? So the attorney should be advising them and letting them know, hey, there's two pieces to this. We've only talked about one. Let's address the other one. So a good attorney should be doing that for anyone who's done an estate plan. Or I would say another place where this comes up, where their parents have told them, yes, we got an estate plan, or yes, we got a will. I would clarify that and make sure that includes both aspects of this. Because if you have one without the other, you could be in trouble. Ben, if you have a will, but you get sick today, there's nothing I can do to help you or take care of you or make decisions for you. And then if we have powers of attorney and the incapacity documents, but nothing that addresses your inheritance after you pass away, that's also a problem. So I hate to say it, but people almost need to self-audit this and make sure, whether it's you're concerned about yourself or you're concerned about maybe a parent or a loved one, make sure that both jobs are, both, think of it like rooms within the house. The estate planning is the house, and we have the upstairs, which is, while you're still alive, and then the downstairs after you're gone. So again, I wish more attorneys brought this up, and you didn't have to do it yourself. But I tell our listeners, unfortunately, you probably need to self-audit this, sadly, and make sure that your plan covers both aspects of it. And if not, you need to talk to an expert and make sure that you get that, you get that hole in the bucket sealed.
Well, good information here. Again, really, estate planning is really about having two plans in one, and really understanding these separate roles is essential really for picking the right people for each responsibility. So hopefully this kind of details it for you so you better understand what you need to be doing. But if you haven't taken care of some of this stuff, or really haven't started planning at all, right, now is the time to do that. It's better to start now than to keep putting it off, right? It's easy to do, but so important to get all these things taken care of. Reach out to Nick at CincinnatiEstatePlan.com to begin that conversation. Or if you have any other questions that maybe we kind of spurred up here today with you by this discussion, reach out to him there. We'd love to hear from you. Again, all that is in the show description as well to make it easy for you. But that'll do it for us here on another episode of Complete Estate Planning. We appreciate you being here. And if you liked it, please subscribe. We appreciate that support as well. And we'll talk to you again soon. Take care.
Are you feeling overwhelmed by estate planning? The process can seem complex, but it doesn't have to be. The Rosenbauer Law Office is dedicated to helping you protect what matters most: your family, your assets, and your peace of mind. Nick and the team will guide you through every step of the process, making sure you feel confident and informed along the way. Take the first step toward peace of mind today. Schedule an introductory call by clicking the link in the description of today's show.
This show is for informational purposes only and does not provide any legal advice. Information on this show may not constitute the most up-to-date legal information. Please do not act or refrain from acting based solely on anything you hear on this show. This show does not form any attorney-client relationship with the Rosenbauer Law Office, LLC. Please seek the counsel of a qualified attorney before addressing your own estate planning needs.